Okay, we are really delighted to have Mr. Ray Zhao from MiniPTALK, attorneys at law, with us in this beautiful morning to deliver his talk. Mr. Ray Zhao, let me introduce him. He's an international trademark team, the head of international trademark team at MiniPTALK, and he's really experienced and very busy with his work. So we are really happy to be able to invite him here. And Mr. Ray has accumulated a lot of practical experience, especially in trademark prosecution and IP enforcement. Yeah, and he's really actively engaged, and he has published a lot of articles in IP magazines and newsletters. And he's also a member of many associations like the International Trademark Association, INTA, European Communities Trademark Association, International Federation of Intellectual Property Attorneys, and the list is so long, I can't even finish. All right, so before we formally begin, let me share my screen. All right. For those of your friends who were unable to register for the talk, right, they can actually surf Facebook NBSMY to watch this webinar live right now. It's happening right now. Please share this screen to your friends or colleagues who are unable to register so that they can watch the live. Or if they would like to watch it on Zoom, key in this webinar ID and password to enter our Zoom webinar room. Yeah? So I'll give you guys some time to do so now. Please grab this opportunity to listen to our distinguished speaker. Right, our distinguished speaker, Mr. Ray Zhao, will deliver a very interesting talk on the strategies in China and the IP trends and some remarkable cases in China. Yeah? All right. Mr. Ray, so can you hear me?
Yes.
Yeah. So China has been facing quite a number of challenges lately. You have the US trade war, you have the we have this COVID situation, and recently you have a ban of WeChat by President Trump, right? So yeah, so how has all these kind of scenarios been affecting the IP landscape in China? Can you briefly let the audience know what is happening in China in terms of IP now?
Okay. I think you raised very, typical questions that I can normally receive from all my foreign friends. Everybody knows, China is facing some challenges, especially with, relating to some, international relationship with US. There's a trade war. There's a, coronavirus still happening in China, and also recently the new ban against WeChat. So actually question whether or not China can still grow as before. And also IP is highly related to economy. So if economy is affected by some, matters like trade war or some bans, whether or not IP will be also affected. As a IP practitioners, I always concentrate on those, situation because I also worry whether, we have a better future for IP. I think, according to my knowledge, in recent 20 years, if you look at the official statistics in China, all IP applications in trademark, patent, copyright increasing. and dramatically increasing. So this is actually somehow a surprise because somebody will think, oh, there is a trade war, there is some challenges, for China, but still IP is highly, recommended by so many domestic Chinese companies and also multinational companies. So that's why if we look at IP, it's completely another, direction. There's small challenges on IP in China still grow very fast. So, yeah.
Right. Because China has had quite a lot of infrastructure for itself, like even for chatting, social media, they have quite a number of social media platforms, and payment platforms built for its local citizens. Am I right? And even for marks that go into China, for trademarks that go into China, it's what we have heard is preferably to have a translated word into Chinese. Am I right? Because it's more widely known as such over there. So in this case, many people have actually asked, is it difficult to enter into the Chinese market? For example, to file their IP into China, is it difficult to do so? What are the potential hurdles, stuff like that?
The signal is not stable. I missed your last sentence. Can you repeat your question?
Oh yeah. People have been asking whether is it difficult to enter the Chinese market and to file their IPs there, because China has had its infrastructure, its language requirement, and people know foreign marks by their Chinese names, stuff like that. Yeah. So can you enlighten the attendees? How is it like? Is it difficult to enter the Chinese market?
Okay. It's also another very common question because due to culture difference, language difference, if someone never, been to China before, probably they will have kind of, impression that China is very difficult to deal with, and sometimes Western media also always want to show some kind of negative pictures of China. So that also pass some impression that China is really difficult to deal with. Actually, I think my answer is very easy. It's quite easy to enter into Chinese market. If you look at the situation in China, how many big companies, multinational companies, have already entered into Chinese market, and how successful they are in Chinese market. And then actually you can know the answer. Some multinational companies have already entered into the market, I think more than 30 years. I think there's an official statistics also, like more than 80% of Fortune 500 companies have already entered into Chinese market. So this is actually a signal, or let's say evidence, which can tell us that China is very easy to approach. And I think for a lot of people who have been to China, and you will realize that Chinese people is very easy to approach, very friendly to foreigners, and also because the economic growth, recently middle class is booming, and a lot of people actually want to buy foreign brands instead of domestic brands. That's a sad news to some national brands in China, but that's a good news for multinational brands. So a lot of people really want to buy, good quality products from other countries like Germany or Switzerland. And even a lot of Japanese cars are very popular in China, even considering, political relationship with Japan. In some years, were not really good, but the sales of Japanese cars still in China is still very good. So those can tell a lot of people that China is very easy for a lot of multinational companies to enter into. And also because the market is really big, I think every big companies and even some medium-sized or let's say smaller size companies also need to concentrate on Chinese market, because if you miss this market, you miss a lot. We always have a joke because currently China has 1.4 billion people. So if one person just buy one bottle of water, and that's 1.4 billion bottle of water. So if you produce water, that's a lot of money already. So don't think too much. China is very easy to enter into. Yeah.
All right, thank you for your clarification. 1.4 billion bottles, that's a lot. And very recently, we've seen a lot of technological advancements in China. And in fact, statistically, the IP filings in China has actually surpassed the US and Japan. And this is a remarkable figure, as we can see. So without further ado, let us move on into Mr. Ray Zhao's IP talk. So to all the attendees who are working, really thank you for taking out the time, and welcome again to joining our mini IP talk. This morning, we are bringing you into China, connecting China. So Mr. Ray Zhao, please share your screen and begin your talk.
Okay.
The floor is yours.
Okay. It is really my great pleasure to share some information about China. Today, I'm going to share something about business strategy and the protection strategy in China. And I'm so happy to share this information, because China, as we briefly talked, is really important. And I practice IP in China for more than almost 20 years. So I think it will be very helpful for some companies who have already entered into the market or are going to enter into the market. So let's go to the first part of the business strategy. Basically, if we look at the official statistics of Chinese economy, in recent 30 years, the GDP growth is really high in China. Even recent years, China still keep more or less 7% GDP growth rate. So it's still very high. And the population in China also grow. As you can see from the table at the right corner, currently China has roughly around 1.4 billion people. So this is a really big market. And for some companies, if they want to enter into the market, because if you look at the map of China, China is really big, very similar to the US. More than 94% of population actually live in the east and China, and only 6% of people live in the western and the northern part of China. So any companies want to do business in China, very importantly, they need to open their shops and you know, explore their business channel, sales channel, and maybe cooperate with some distributors in the eastern and the southern part of China. That's very important. Part of China, you know, are same important as others. As a result, we can see recent 10 years. This is only up to 2017. So the GDP growth rate kept roughly around 7%. Due to the coronavirus, the situation is a little bit complicated. We have a smaller increasing rate, but still very good compared to other countries. And from 2 years ago, China enacted a new policy, which is called One Belt, One Road. New policy encouraging Chinese companies to invest some other countries that pass by this belt and the road. So One Belt is actually start from Quanzhou, as you can see from this map, from here to Vietnam, and pass by Malaysia, Singapore, and to India, and Africa, and some Middle East countries, and eventually go to Venice of Italy. And also there is a one road start from Xi'an, which is my hometown. And this road will pass by some Middle Asian countries and arrive Turkey, Russia, and also France, some European countries, and eventually also reach Italy. So all the countries which nearby this One Belt and One Road will be benefited because China will invest a lot of in those countries. And as a result, you can see some companies from those countries also want to invest in China. So the relationship, economic relationship between those countries and China will be definitely improved. IP is highly related to economic growth. So after we know the economic growth rate in recent 10 years, so let's look at the IP applications in China. So this is a table for trademark applications from 2000. From this table, you can see that the filing numbers increasing almost every year. And last year, actually, we have nearly 8 million new trademark applications. I think that's 8 times than US and other countries. Among all the classes, because China is also NIS Convention, member states of NIS Convention, we also have 45 classes. Among all the 45 classes, for trademark, class 35 is most popular class in China. And then class 25 is the second one. Class 9 is the third one. So why class 35 become more popular? Because e-commerce is booming now. So a lot of companies want to open some online shops. They want to do some retail and wholesale services. Some companies actually, need to open some shops on Tmall and Alibaba. As there's a requirement from some online shops, from some online platforms in China. For instance, JD And Tmall, they will require some brand owners to have trademark registration in class 35 in order to open online shops. So those are all the reasons why class 35 become much more popular than before. And class 25, it does not surprise me because a lot of fashion brands, they need to register class 25. So as always, class 25 is always very popular for a lot of fashion brands. And class 9 is, as you know, some electronic devices like cell phone, laptop, and video devices are all in this class. So that's why class 9 is also very important. This is a table that you can see all different type of applications on trademark side from 2013 to 2017. If you look at each line, you will realize that almost every type of applications actually increase every year. And the trademark office of China currently is very busy because every type of applications increase, and they do not have sufficient examiners to deal with all the increasing part. So currently the office opened some branch offices in 5 cities in China, and they recruiting more examiners to solve this increasing part. This is a table. You can see the transfer applications from 2013 to 2017. The reason why I put this and I want to share this is because as you have already know, the filing numbers really increase a lot. And there are nearly 25 million valid trademark registrations in China, plus 8 million new trademark applications. That means there are more than 33 million prior rights. As a result, a lot of trademarks are rejected due to some prior rights. And the combination of English character is somehow limited. So it's very easy for some new trademark applications to be rejected due to some prior rights. Last year, the rejection rate was roughly around 42%. So this is really high. So a lot of companies actually are facing the difficulty to register trademark in China because the rejection rate is really high. So some companies, come up an idea, oh, why not I just buy a trademark from some current trademark owners, then I don't need to wait for the examination, and I can get the registration directly. So that is one of the reasons why transfer application go up. And another reason is recently there are a lot of applications we call bad faith applications filed by some bad guys. And one of the reasons why those bad faith filers want to file trademark is because they want to sell the trademark they filed, which belong to the original brand owners, to the real brand owners. So some companies cannot wait because they really want to enter into the market. Without trademark protection, they cannot enter into the market. So sometimes they negotiate with some bad faith filers, and just in order to reduce the time that they need to spend on the legal procedure. So they directly purchase some trademarks from some bad faith filers. So that is another reason why transfer application also increased a lot. Very importantly, this table tells us that we need to register our trademark as early as possible, because China is a country which still follow first to file, first to register doctrine. So that means who file earlier, who get the registration. So if some companies miss the opportunity to file their trademark earlier, then there is a risk for them that their trademark might be registered by some bad faith filers. So, and eventually they have to spend much more money to purchase those trademark back, or maybe take legal actions, but the legal actions also cost a lot of money. So that is very important to tell us that register your trademark as early as possible. This picture, you can see that the copyright applications, also increased a lot. So from 2010 to 2017, it's almost 20 times. And photographic are most popular copyright filed in China, and then some written font art, and also some movies, videos are also very popular, and also software, computer software. So we have a lot of trademarks, patents, and copyrights filed before Trademark and Patent Office, and also before the Copyright Office. So as a result, there are more disputes between different IP owners. And if we look at the official statistics for IP litigation in 2019, you will see that it is a lot, because last year, the administrative litigation, IP administrative litigation was near 16,000. And among all the 16,000 IP administrative litigations, patent enjoys 8%, roughly around 8%. Trademark enjoys more than, sorry, this is wrong data. I think this is more than 80%. And there are more actually civil litigations. As you can see that there are roughly around 400,000 IP litigations in China. And patent civil litigation enjoy only around 2%, 2.64. Trademark actually is a majority. As you can see, trademark has 65,000, which enjoy 25%. And copyright also has a lot of litigation, more than 300,000, roughly around 300,000. Yeah. So back to our question, how to enter into China. We all the time knows that there are three ways to enter into China. One is to set up your own subsidiary in China, like Google. And the second one is to choose a good partners in China and set up a joint venture with Chinese companies, and then use the joint venture to explore Chinese market. So this is a second approach. The third one is just look for and just let those distributors help you to sell your products in China. So those are major three ways to enter into Chinese market. However, a lot of my clients and my friends always ask me that, "Hi Ray, you mentioned three ways, but which one is the best?" My answer is there's no best because every coin has two sides. Why? Let's just briefly introduce the good side and the dark side of each way. For the subsidiary, Google entered into the market roughly around 2000, if I remember correctly. They set up a subsidiary in China, in Beijing, and because they don't want to work with some Chinese partners. And eventually, Google violate some internal regulation of China. So as you know, Google currently is banned by China because they have some kind of serious violation of laws. And in China, Google used to have a competitor. I'm pretty sure you know this. It's a Chinese search engine which is called Baidu. And in the very beginning, Baidu was tiny compared to Google. And in order to compete with Google, Baidu actually come up a lot of ideas how to be closer to Chinese consumers. So in the very beginning, Baidu had a slogan which is called "I know you do not know," which is actually you can understand they want to say Google doesn't understand Chinese culture, and this become really true, and this also tell why Google eventually quit Chinese market, because they don't really understand Chinese culture. They don't know how to deal with some local governments in China, and they don't really understand how to respect some cultural things. So that's why they were not so successful in China. So this is the dark side of the subsidiary. But the good side of subsidiary is because this company fully controlled by foreign brand owners or IP owners. So you can fully control the risk. You don't need to worry that some of your IP might be disclosed to your partners or to some relevant Chinese partners. And you can completely build up your business in China. But as you can see, this approach is a little bit slower because you have to build up your own sales channel. You have to recruit your own people. That all takes time. So if you want to grow faster in certain period, subsidiary is not the best solution. But if you really want to a stable structure, and subsidiary might be better. So this is a very brief introduction of subsidiary approach. Then let's come to the next one, joint venture. Some big companies, like some car manufacturers, they all the time, when they enter into the market, they want to find a Chinese partner, very big one, to work with, because they can use their factories. They can also use their business channel, sales channel, and also some shops they have. By this way, they can grow very fast. So this is a good side of the joint venture. And also Chinese partners know much better than foreign brand owners because they know the culture. And so this can be the faster way to build up the reputation of the brands. However, the dark side of this approach is also very obvious. In China, we have a saying for human marriage, which is called 7 years crisis. This is also happened to joint venture because as the Marcus has already described in the beginning, there is a culture difference, there is a language difference. Even some companies, they can set up joint venture, but because both companies must have different company culture, and also two countries have different culture as well. So after certain years operation, there might be some problems come up because, for instance, maybe one party want to be more successful. One party says, "Oh no, I think currently the situation is good. We don't need to be so aggressive." Then the problem will come up. So after certain years, there might be very serious conflict or problems or even quarrels in this joint venture. So very famous case between a very big company in France, which is called Danone, and a Chinese beverage manufacturer, which is called Wahaha. They set up a joint venture in Hangzhou. But after, I don't really remember whether that's 7 years or not, but after certain years, they had so many disputes against each other. So eventually, they brought a lawsuit against each other in China and in Sweden, in some arbitration centers. If I remember correctly, there were more than 18 or 20 litigations or arbitrations between those two companies. This is not really a happy ending story. So this can be the dark side of the joint venture. But some other joint venture also survive. For instance, in car, industry, some German car and Japanese cars, they work with some big Chinese car manufacturer as well. And currently, their joint venture, I think, is more than 10 years old already. So I think they are running quite well. So it's not really, certain that joint venture is not good, but you have to be really careful that whether counterparty has the same value culture with you. Otherwise, in the future, there will be some problems. So this is both sides of joint venture. The third way is distributor. This way, for some IP owners, they don't really need to set up, a subsidiary. They don't need to set up joint venture, and they can save money for subsidiary and joint venture. The only thing they need to do is to find a good distributor in China. So this is the most, I would say, cost efficient way. So the good side is also distributor knows much better than foreign IP owners. So they can help a lot of companies to sell the products in China. So this is also very good. The dark side is sometimes you have to sign agreement with those distributors, and the term sometimes might not be so long. Some agreement I have ever seen can be 2 years, 3 years. Then after 2 or 3 years, whether or not those distributors can still be your distributors, this will be a problem, because if you terminate the agreement, then you have to find another distributor. And the previous distributor, they know how to manufacture your products because they have already worked with you for a very long time. And some distributors, after the termination of the agreement, they have the ability to produce very same quality yours, and that can be very dangerous, as you understand, because some distributors, they have to survive as well. Then they might still manufacture the same products, and is very dangerous, and also sometimes they might disclose some technology to other parties as well to get some money. So that's the dark side for the distributor. Okay, so in conclusion, those three ways are major ways to enter into Chinese market. But which way is the best? There's no answer. You have to choose each carefully and better match with your company culture. Better find some partners in China which really reliable, and better to conduct some investigation or due diligence before you work with those partners. So those are all the tips. Okay, these slides, this page I will skip because we don't have much time left. Max only gave me 1 hour. I think I a little bit after time. So how to protect business through IP? If you have already entered into the market, if you have your business interest in China, then those 4 are very important. The first one is you really need to be very creative, because if some technology are not really advanced, then you might be really not in good position, because competition between different companies is very serious in China, and every company wants to come up new ideas. Every company wants to enjoy much more market share. So whether or not your products can be more competitive, it will be depending on how creative of your products. So try to invest more money on your R&D center. Try to make your products can be creative every year, so that you can really compete with your competitors. And then after you create some IP, next step is very, very important, is to apply those IP in China. Because if you create something but without any protection, that's another disaster, because as we briefly described, your trademark might be filed by some competitors, or maybe by some bad faith filers. Your patent might be copied, your copyright might be used by your other infringers. So without protection of IP, that's nothing. So it's very important to apply. And some companies that do not know how many IP they need to apply, all of them or just one type of IP. So that's another lesson, but at least they should know they need to apply for their IP in China. And some companies, some of our clients, always ask me the same question. Hi Ray, I have my IP registered in Europe, in US. Can I get protection in China? The answer is absolutely not, because IP rights in other countries will not automatically get protection in China. So it's very important to file in China rather than just rely on the IP rights in your home countries. Okay, and the third step is monitor. After you apply for your IP rights, after you obtain IP rights in China, it is very important to monitor, because in China, business is really very active, even including some infringers. So we help some brand owners to monitor some infringers online. How you can never imagine that how many new links on some big platforms like Alibaba and JD. We have one Italian luxury brands to monitor their infringers online, And almost every day we can find more than 3,000 new links relating to their products. And they're using our client's trademark. So it is really important to monitor online and on-site, and also sometimes some trade fairs. We represent a guitar brand, a very famous guitar, American guitar. And we attend a trade fair in Shanghai. In the same trade fair, an infringer also sell the products in the same trade fair. So if you don't monitor, you never know that there is an infringer using your trademark. So monitor your trademark is very important because you have to take action against them. Otherwise, your infringer, your competitor might share your business interests, and also might be somehow damaging your reputation of your trademark. And the very last step is to sign NDA with all the parties that you have to disclose your IP. When you set up your subsidiary, you have to recruit some staff, and some staff will know your technology. So you have to sign NDA with your staff. When you work with some distributors, and you have to also tell them how to manufacture your products. And there are definitely some details, and you have to also reach the agreement with NDA. And when you work with some partners, it's also very important. So all the time, don't forget NDA. So let's come to the second part, protection strategy. So basically in China, there are too many different ways to protect your IP. As all of you know that you can protect your IP through trademark, copyright, patent, and domain name. You can also protect some of your technology under unfair competition law, including the trade secret. You can also, maybe protect something by contract. So it's a lot of different, procedures that you can rely on to get protection in China. I would like to briefly introduce a very common questions that I normally can receive from some of my clients, because many of them ask that China is a member state of definitely Madrid Protocol. So some companies want to enter into the market and they protect their trademarks through Madrid Protocol. Some companies directly file their trademark in China. So which one we should rely on? Both of them or just one of them? This is a very typical question. And whether there are some advantages and disadvantages. So basically, the picture you can see here is a certificate issued by WIPO for the international registration. By this certificate, you can realize that this certificate is issued by WIPO. So there's a signature of the director of WIPO. But when you want to enforce this right in China, then you might have difficulty because this is in English. Firstly, you have to translate this into Chinese. And secondly, even you can translate, some authorities that might not trust you because they might question your translation. They might also question whether or not this is true. So sometimes for the international registrants, they have to file another additional application before Chinese IP office. They have to apply for a certificate issued by Chinese Trademark Office. So this is a certificate issued by the Chinese office for the international registration. From this one, you can see the international registration, especially for the goods and services, were translated by the office automatically. And then there's a CHOP, the stamp of Chinese Trademark Office. So by this one, when you want to enforce your right, it will be acceptable for the Chinese authorities. But this is an additional procedure. You have to spend much more money on this, and also time is an issue, because when you find some infringers, you want to take actions immediately. And if you have this certificate issued by Chinese Trademark Office, you cannot take actions immediately. You have to apply for this first. And this procedure takes sometimes 1 or 2 months, and that will delay your action against the infringers. So, comparison between Madrid and the national. Madrid, as all of you know, that it is very cost efficient. So if you want to designate many countries, Madrid is still the best, choice, and also very easy to manage portfolio, because for some trademarks, for instance, maybe multiple applications, including so many classes, it is easy because there's only one trademark, one number, and cover, so many countries, very easy to manage. This can be the, advantage of Madrid. But there are also some disadvantages for Madrid. The first one is central attack, because international registrations is actually based on their own basic applications filed in their home countries. So if there is any, danger against their basic applications, then their international registration might be also dangerous if the registrant, in the future will not take, actions to move their international registration to domestic, then their international registration can be invalid. So this is the first one. The second one is the cost issue I have already briefly described, because you have to pay for international registration, but when you want to enforce the right in China, you also have to pay for the procedure to get the certificate, and that fee actually is somehow equivalent with the national filings. So that's a double cost. And the third one is wrong translation, because all the goods and the services you can see from the certificate issued by the WIPO actually were translated by machine. So the picture you can see from here, all the goods and the services actually translated by machine. If those goods and the services translated by machine, then in the future, there's a problem, because there might be some wrong translation first, and also some, translation might not be so good. I remember I represented a German company, and they also have an international registration, but the description is very, very long. And the sentence for the translation is almost like a sentence, like 3 lines. So when we enforce this right before the court in Shanghai, the judge actually asked us, "Hi Ray, can you explain what product this is? Because this is too long." So it's not easy to enforce, and the translation might be a problem. And also, class heading is another issue, because for national filing, we do not accept class heading. But for international registration, because that's the agreement between China and other member states. So for China, we have to accept class heading. But some companies that might think, because they have the class heading descriptions, they think they cover the whole class. But actually, class heading will be also translated one by one. So eventually, in China, we have a so-called subclass system. In each classes, there are a lot of, and the class heading will be translated in some subclasses, but not all subclasses, which will cause a problem, because some subclasses which not covered will be the free space for third parties to apply. Then that is another potential risk in the future. Okay, this is the fourth disadvantage. The fifth one is the term. According to the trademark law, and also according to the new examination pace, for the new trademark applications, now Chinese Trademark Office can finish the examination in 5 months. However, for Madrid, if you have the experience, you will know that from your home country, you file the application, and sometimes that takes more than 6 months for WIPO to transfer all the files to some designated countries. And each designated countries, they also need to spend certain time. It's different. But for the international registrations designated China, normally will be examined more than 18 months from the application date of that international registration. So that's a little bit longer. So for some companies which really want to get the registration earlier, then international registration might not be the best choice, because they have to wait longer. So in that case, better it's a better option. Okay, so all the disadvantages for international registrations are all advantages for national filings. So you don't really need to worry about the translation of the goods and the services, because when you use national filings, your Chinese agency will help you to translate perfect Chinese goods and services, and that will also match with Chinese classification. And class heading cannot be accepted, but you can choose more goods and services which you cannot really find in the international classification, because we have a lot of local, we call the local goods and services. That is a very special one. And also the term is shorter, so you can reduce the time to wait for this procedure, and you can get protection earlier. And also it's easy to enforce, because the registration certificate is in Chinese. All the Chinese authorities will recognize, and also that it is issued by the office with office chop. So it's quite easy. Of course, there is also disadvantages, because currently, according to our trademark law, there is a, multiple application is available, but it is not so convenient because you only have one opportunity to file divisional applications. The whole multiple application has to remain all the time, unless when you face rejection. In that case, you can file divisional applications, and miss that opportunity, then you have to keep all the multiple applications as a whole. Then in the future, for instance, if you want to transfer one class to another party, that is not impossible, because if you want to transfer, you have to transfer all the classes to that party. So that is why we don't really recommend to use multiple application in China for national filings. So the portfolio will be a little bit bigger compared to international registration. So this will be kind of the disadvantage of national filing. And additional cost for national filing, no. Normally, there will be no additional cost. But of course, if you want to change your logo from one font to another, if you want to maybe enlarge the scope of protection, let's say you want to add one good or another services, or maybe more services, then you have to reapply the trademark. So those are the kind of disadvantage. But for me, I think that's not a problem at all, because in that case, you have to refile anyway. Okay, so that's a very typical question. And now we come to a little bit of patent part. Just a very brief introduction of the different patents. In China, currently we have three types of patents: invention, utility model, and the design patent. For the invention, it is very different compared to utility model and design, because there is no substantial examination for utility model and the design. In other words, as long as you apply, you probably will get the certificate issued by the patent office for utility model and the design, because there is no substantial examination. So in the future, when you want to enforce your utility model and the design, sometimes maybe counterparty also might have the same utility model and the design approved by the patent. And maybe sometimes counterparty will also find some prior art which can invalidate your utility model and design, because there is no substantial examination. For invention, there is substantial examination. So the quality of invention is much higher than utility model and the design. And the term for invention is 20 years. Utility model and the design only have 10 years. So sometimes some company might choose to file invention together with utility model, because utility model you can get certificate a little bit earlier. Normally now it only takes roughly around 6 months. However, for invention, that will at least take 1.5 years. So if you want to enforce your patent earlier, sometimes maybe utility model will be the better option. Okay, let's go on. So how to, after you obtain your IP rights, how to enforce your IP rights in China? Basically, there are 4 ways. The first one is administrative procedure. Second one is judicial procedure. Third one is criminal procedure. And the last one is online procedure. The first procedure is quite different because a lot of countries might have judicial procedure. administrative procedure is I think, very unique in China, because China is very big and there are in China. If all the parties, let's say, bring their lawsuit before the court, our courts will be super busy, and we don't really have that much judges to deal with all the IP issues. So it is very important for China to set up some local IP offices which can also solve IP issues. So in almost every cities, districts in China, there is a local IP office which you can also rely on to enforce your IP rights. Those local IP authorities, they can issue injunction, they can impose a fine against the infringers. But if you want to claim damages, you have to go to the court. But generally speaking, for the smaller amount of infringement, administrative procedure will be a very good option, because it is faster, normally only take 3 months, and cheaper. It's not really like litigation, so the cost will be cheap, very less than litigation. And of course, we also have border control. So if there's an infringement, you can also rely on some custom for all the import and export goods to stop some infringing products. So this is the first procedure. The second one is judicial procedure. Judicial procedure is quite similar to other countries. I want to introduce some details that in China, we have in total 4 level different courts. The lowest level is a district court, and then intermediate court, and then high court, and then Supreme Court. Okay, those are 4 different level courts. And we only have 2 instance litigation. If you bring the lawsuit before district court, then intermediate court will be the final court. If you bring the lawsuit before the intermediate court, then high court will be the final court, depending on how much damages you want to claim, because there is a judicial interpretations that what kind of cases should be heard by district court or intermediate court. In order to promote IP protection, China set up 3 IP courts 4 years ago in Beijing, Guangzhou, and Shanghai. So 3 IP courts. But only the IP courts in Beijing can hear IP administrative litigation. Of course, they can also hear IP civil litigation. And the IP court in Guangzhou and Shanghai can hear also other IP litigations in that region. And apart from those 3 IP courts, Supreme Court also set up more than 16 IP tribunals in some large intermediate court in China. So those are all the new measures that were taken by the Supreme Court and the Chinese government to enforce IP protection in China. So those are judicial procedure. Criminal procedure is quite simple, as long as the amount, or let's say the value of the infringing products reach some requirement of the criminal law, then infringement can be will be subject to criminal law, and the legal representative and the president of that infringing company might be also charged for the criminal, might be criminal charge, sorry. And the fourth one is online complaints. So as e-commerce is really booming in China, there are so many different platforms where you can sell your products online. So of course, there are some major players like Alibaba, Taobao, JD, Tmall, but there are also some other new emerging platforms like a WeChat official account, some Pinduoduo, and VIP. We have so many different platforms where you can buy products online. But as you can imagine, there are a lot of infringing products that you can also find on those platforms. So if you find some links or counterfeits on those platforms, you can file complaint before those platforms. And each platform, they have their own rules to follow. So you just need to follow their rules and then take actions after the action is accepted by the platform. The platform will delete some links, and sometimes they will take down the products and also maybe close the web pages or some accounts. Another new platforms you can also find is some app stores like Apple stores or Android stores, and also some other big companies that have their own app stores. And then some companies might use your trademark as their app name. So that is also not a new type of infringement. And then in that case, you have to file complaint before Apple or let's say Android. And they will also have their own rules. You just need to follow. So eventually, if they accept your complaint, the name used by those apps will be deleted and also will be changed. So those are the 4 different measures. So 2 pictures you can see here is the administrative procedure that we have so many local authorities. When you file a complaint and those officials will come to the fake stores or fake shops and then all the products, if they finally determine that that is an infringement, that will determine all the infringing products and made the decision. The right-hand side, you can see this is a decision actually made by the authority on site. It's quite faster because you don't need to wait. So they come to the shop, they consider and they determine. And then if they think this is infringement, they can issue the decision right away. So it's quite, convenient. 2016, there are more than, you can see the data here. There are more than 180,000 times measures were taken by the local authorities. That's quite a lot. Those are all the details of the decisions. I didn't translate because that's too much. The only thing I want to let you know from here is that there are 3 lines. The first one is the injunction, the immediately stop infringement. The second one is that deter all the materials and the infringing products. The third one is they impose a fine against this infringer. So this is quite a convenient way to enforce your rights. And when the when we bring the staff of local authority to those kind of on-site, those kind of shops, if after inspection we found that the total amount of infringing products reached to the requirement of criminal law, then we can inform this situation to the public prosecutor, and they will bring the action against the legal representative of this company for the criminal charge. So this is one of the criminal decision. I also did not translate all of them. There are 3 lines I want to draw your attention. According to this criminal decision, firstly, the legal representative of this company was put into the jail for 4 years and was imposed a fine for nearly $500,000. So that's really a lot. And all the infringing products were detained. So this is a action from civil action to criminal action. For the customer matter, that's also very useful, because when you have trademark or let's say IP rights in China, you can record your IP rights before the general administration of customer, and then this general administration of customer will share the information with all the local level customer. And then local level customer, they will inspect all the products which might use your trademark. When they find some products which using your trademark, but without your authorization, they will stop all the shipments. So those are all the pictures you can see how they inspect the products. It's also very useful. So very importantly, you have to record your IP rights before the customer. There are also comparative. If you do not record, the customer will not automatically take the measure. You have to find the information and then you inform the customer can stop. But when you record your IP rights, even you for the IP owners, maybe they don't know the information, but the customer can take actions automatically. So it is highly recommended to record IP rights before the customer in order to get this protection automatically, rather than you have to monitor all the time, because you cannot really monitor all the things which is happening in different cities in China. And it's very important to organize some customer training, because as you can see from some pictures, there are a lot of infringement for the import and export products, and sometimes the staff of customers, they might not have enough ability to distinguish which is a real product, which is a fake one. So for some important products, it's very important for the brand owners to go to some customer to give them a training how to distinguish the real one and the fake one. We help some red wines producers and some scissor producers, some machines producers, some fashion brands to train some customers in Shenzhen, because that is a very important customer. And then after we give them a training, that customer actually stop a lot of fake counterfeits. So that is very helpful. For some online complaints, I just briefly introduce this. You have to set up your account. You have to follow their rules. But most importantly, after you find some potential counterfeits, you have to submit your IP right certificate. That's for sure. Sometimes you also have to submit some kind of report, because they will not just take action because you submit the certificate. You have to say how you can realize the potential infringing products is counterfeits. Then you have to compare the first two picture I put here, you can see is a Parma ham because we represent the Parma ham. And on Taobao and Tmall, we found a lot of hams also from Italy, but not from Parma. They also call themselves Parma ham. And even some factories in Parma also call themselves Parma ham. That's a little bit tricky because in Parma is a city in Italy, but only a small region in Parma city can produce Parma ham. So let's say Parma city is bigger than the region in Parma which can produce Parma ham. So some factories in Parma city, but not really in region of Parma ham, also call themselves a Parma ham. That is also kind of infringement. So we help Parma ham to take actions online against this kind of misuse, and that was quite successful. And those two pictures, you can see that the left-hand side is a real one. The right-hand side is a fake one. Just because they use the different picture, small pictures here, we can distinguish. Oh, that is a fake one. And those two is a cosmetics. The left-hand side is fake one, just because the color of the bottle is lighter than the right one. But this one is the fake one. So it is very important to know that there are some counterfeits you can find online. It is more important to distinguish, to tell the details, the difference of details between real products and the counterfeits, how they are different, and then you have to show those details to those online platforms. After they accept, then all the infringing links will be deleted. Okay. I think I run out of time. It's half an hour more than Mark's gave me, but I really want to share more information with you. So I believe some of you might also have questions. So I want to leave my time a little bit to the Q&A part. Yeah. Marks? Yeah.
All right. Thank you very much, Ray, for the excellent presentation. We are sorry to the attendees for the delay. So next time when you're in China and you meet those officers, don't be scared. They are not coming to check your passport. They may be coming to catch the infringers. Am I right? Okay. Really, personally,
exactly.
I have...
Yes.
Yeah, personally, I have a lot of questions to ask Ray, but because of time constraint, we will just restrict the questions. We've got one question from the attendee, Ms. Tufshin Saikan. She said, thank you very much for your PowerPoint and your time. My question is that we know that China have been adopted the amendment to the trademark law last year, intend to use requirements for trademark applications. Yeah. So how is it going, the procedure and the requirement nowadays?
That is quite interesting because as you know, we amended trademark law last year, and the reason why we introduced intend to use in our trademark law is because there are a lot of bad faith applications filed in China. Some bad faith filers actually, I remember the beginning of last year, there was one company located in Guangzhou filed more than 5,000 trademarks in one day, and in another day filed more than 10,000 trademarks. So in 2 days, that company filed more than 15,000. And it is so obvious that this company will not use all the trademarks they filed. So why they file so many trademarks? Because they want to sell to some trademarks to the real brand owners. They are trademark squatters. So how to deal with this kind of matter? Because in our trademark law, the principle is still first to file, first to register. So there is no prohibition to stop this kind of bad faith filings. If let's say if they have no direct evidence to prove they are in bad faith, then how to stop them? Previously, our office just reject those kind of applications if the total amount is really a lot, let's say 15,000. But the problem will come later. How about some companies just file, let's say 10 trademarks or maybe 20 trademarks, but might belong to different trademark owners? Then that's another question, because Victoria's Secrets also filed opposition against some company filed for the same trademark in another class, but eventually they lost opposition before the trademark office, before IP courts, before high court. So in that case, according to the decision of high court, the high court held that 20 trademarks filed by that applicant is not too much. And then this might give those kind of bad faith filer kind of space in the future to continue to do this kind of bad things. So we need to stop. We need to show that China is really willing to protect IP and protect IP brand owners. So we have to introduce intent to use. If some trademark applicants, they cannot show that they have intent to use, then this kind of trademark should be directly rejected by the office, even without any substantial examination. So this is a new actually regulation against the bad faith applications. Of company might also worry because they have defensive mark. Like let's say some company, their major business might be just in one class or in two classes, but in order to defend their trademark better, they might apply for 45 classes. In that case, whether or not that can be considered also, kind of violation of intent to use, the answer is no. No need to worry. The action will not be taken against that kind of defensive mark. It's only against some bad faith filers. Yeah.
All right. So we've seen that China has been stepping up its regulations to counter this bad faith regulation by introducing this intent to use requirements, right? So as we are aware, because this is before use, you have the intention to use. So what about those that after filing, and we are aware that after filing, you have to also use your mark or else it's subject to invalidation. So in China, how many years is that? If you don't use, how many years? Then it can be invalidated?
This is a really new regulation. The new law actually came into force last year. Up to now, I think not so many cases that you need to really show that you have already used the mark, or like the US practice, you don't need to really show that you have already used the mark. And how the trademark examiners determine whether or not you have the intention to use. It's quite controversial, because I also ask the same question to some examiners. How you determine this? Because it's difficult. They normally reply, oh, I will search the web pages of those companies to see whether those are, some companies really engaging in some business. And I also will search what kind of trademarks this company, apply for. Trademarks belong to this company, or trademark belong very obviously to other companies. And then I will determine whether or not they have an intention to use. So this is a new regulation. I think even for the trademark examiners in China, they are still learning. They are trying to, trying to figure out some new regulation, how to determine what is an intention to use. But at least this to some bad faith filers, they will not easily to register trademarks belong to other brand owners. Yeah.
Okay, thank you, Ray. Oh, we've had one more question coming in. What if the brand has been established in their home countries? They plan to extend the business to China and filed the trademark as defensive mark in China, but failed to establish the intent to use evidence. So what can they do?
No worry. In this case, their trademark will be definitely approved because they are not bad faith filer. Then the doctrine of intent to use will not be applied in this case. But after this trademark is registered more than 3 years, that might be a problem because we have a non-use cancellation. After 3 years after registration date, if the registrant cannot show they have ever used this trademark in the past 3 years, then any third party can file non-use cancellation action. But that action can be only filed 3 years after the registration date.
So if they have used the brand in their home countries, can they use that as an evidence of intent in China?
Unfortunately, that will not be counted because even the use evidence in Hong Kong and Macau, and even including Taiwan, will not be counted as valid use evidence in China. Yeah.
Okay. So not even an intention to use it in China. You have
no, that will not be counted as a use evidence in China.
Okay. All right. So after filing in China, we have to use it within 3 years, right, in that country, or else it may be cancelled by other parties.
I mean, non-use cancellation action is just a potential action. For instance, a lot of our clients, they also file, they also cover in entire 45 classes, but maybe among all the 45 classes, maybe only 2 or 3 classes will be affected by non-use. So the percentage is really low. This is the first thing I want to emphasize. The second thing is, as I mentioned, this action can be only taken 3 years after the registration date. So let's do a simple math. From the filing date of some trademarks, it will generally take the trademark office roughly around 1 year and 1.5 years to approve this application without any rejection, without any opposition. Let's say everything goes very smoothly. So that will be 1.5 years, let's say. And then after that 1.5 years, 3 years, a third party can take non-use cancellation action. So that is already 4.5 years. So basically, even without any use evidence, in this 4.5 years, you have protection. It's already enough for some defensive purpose. And then for the non-use cancellation action, it will also take roughly around 1 year, sometimes 1.5 years, for the office to make decision. So theoretically speaking, even you do not have any use evidence, but that procedure will take another 1.5 years. And before the office make the decision, the status of this trademark is still registered. So 4.5 years plus another 1.5 years, that's already 6 years. So I think for the defensive purpose, this is already enough. And of course, we have so many other strategies to use. You can also try to file a new backup application for the same trademark in the same class, and the new backup application will be definitely published. And then any party want to file non-use cancellation action against the backup application, they need to wait for another 3 years. So it's like game never ending.
Yeah.
Yeah.
All right. Thank you very much, Ray, for your detailed and expert explanation. Yeah, so our webinar, because it's been delayed, our webinar is coming to an end. If there is no question, we shall end this talk. But before that, let me just introduce again our next talk. Okay. After China, our mini IP talk will be bringing you guys to Europe. Its title is Explore Europe. So we will look at the European market now and the options for their IP prosecution. So save this date and register for the webinar. For more information and updates, you can follow our Facebook at facebook.com/nbsmy or visit our official website at mbs.com.my. Yeah, so our webinar is coming to an end. Thank you very much to the attendees and our speaker, Mr. Ray Zhao, for spending these 2 hours here, almost 2 hours in this webinar. Thank you very much, and we shall say goodbye. Bye-bye.
Bye. Bye-bye.
Thank you, Ray.